Okay, I'm gonna go to broadcast now. I'm gonna press broadcast.
Right on time.
Good afternoon and welcome to today's webinar. We have a webinar about legal tools to help you and your loved one. My name is Juliana Valencia and I'm a caregiver specialist with Fairfax Area Agency on Aging. You should have received an email this morning with the speaker's slides, so you'll have them for your reference in the future. It's not necessary for you to have the slides open during the presentation. You'll be able to see those. You can ask a question at the end of today's presentation by typing it into the Q&A box at the bottom of your panel. Today's presentation is being recorded and a recording will be sent to all registrants by early next week. There will be a brief survey as you signed out, so please help us by giving us your feedback. Now it is my pleasure to introduce today's speaker, Rory Clark, who has more than 30 years of experience in the areas of law, most relevant to older adults and people with disabilities, including wills, trusts, Medicaid planning, guardianship, special needs trusts, advanced medical directives, probate, state and trust litigation, veterans benefits, durable financial powers of attorney, and trust administration. Rory's personal experience has shaped his family-centered philosophy on estate planning and elder law. He is a nationally recognized practitioner, speaker, legal author, and educator. In 2019, Rory published his first book, The Family Estate Planning and Elder Law Guide. He is a member of the National and Virginia Academies of Elder Law Attorneys and is the founder of the Loudoun County Elder Care Council. Rory is going to share his knowledge with us today. So thank you, Rory, and welcome.
Thank you, Juliana. It's a pleasure to be here today, and I welcome everybody who's joining from your own corners of the world during this COVID experience. And I look forward to speaking to you today about some of the tools that we use to help families support their loved ones. Sometimes it's the clients themselves, sometimes it's couples, sometimes it's children and grandparents. But one of the interesting things about this area of the law that is particularly motivating for me is that it's really all about relationships and family and getting help to support our natural priorities in life. So I'm appreciative of the opportunity to come and talk for a few minutes about some of the things that are common questions as folks get into an area that typically is something they just don't have a lot of experience with, from the past. So let me scroll on to the next page here. The first thing I wanted to explain, Juliana introduced me as an elder law lawyer, and sometimes people get confused right off the bat because that can be a term that they haven't ever heard of. I'm an estate planning lawyer. I've been an estate planning lawyer since the 1980s. But for the past 10 years or so, I focused my practice exclusively on elder law. Here's the difference. Estate planning lawyers really focus on what you might call death planning, making sure property gets to the right place when people pass away, and administering estates and trusts, that kind of thing. In fact, we spent most of our time trying to reduce the federal estate tax on families. Elder law lawyers came into being about 20 years ago when the question clients were asking changed from, Rory, do I need a plan? What happens if I die? More often the question became, Rory, do I need a plan? What happens if something happens to me and I don't die? And there's a number of factors that have created a perfect storm that's never existed in the history of the world before. And we as loved ones really don't have a lifetime of experience to deal with these new circumstances. People living longer, having new disabilities, dementia for a long period of time, doctors keeping us alive, skyrocketing costs. Dementia seems to be exploding as an issue. And so the way I describe elder law lawyers is we're really life planning lawyers. We help people focus on the issues for the decade or two before end of life. Of course, we deal with end of life issues as well, but our real focus is on quality of life. In particular, let me show you here on my next slide. Why am I having a hard time? There we go. Our focus is on preserving dignity and an appropriate level of independence for people. Some folks are totally incapacitated. They may have been in an accident. Others may just need a little bit of help as they age. So there's three areas that we tend to focus our energies on. One is helping people make decisions. Another separate category is protecting our loved ones. You've probably heard the phrase elder exploitation. I was working on a case this morning where somebody's unfortunately within a family taking advantage of a parent who's no longer able to manage their own affairs. Sometimes it's protecting our loved ones physically in their physical environment. And then because this world runs on money, helping people find ways to pay for their care can be very important. So these are the three main focuses of how we support people, families, loved ones as people are aging. How do we support good decision making? How do we protect those who are most vulnerable? And how do we make sure people have the resources to do what they need to do? So let's talk about tools that we use to support decision making. And I use the word support right now advisedly, because we're talking about a phase here where our client may very well be participating in the decision making. They just need some assistance. So we're not talking about taking authority away from anyone. We're just simply talking about supporting them to allow them to have the highest quality of life, independence, and appropriate support. I think logically, a great place to start is to talk about something called an advanced medical directive. This is something in the 80s we called a living will, and many people are familiar with that phrase. A living will and an advanced medical directive is a statement by the client, the patient, about how they would like care to be addressed if they're in a position where they're not able to articulate decisions at the time. So the point here is this is a communication from our client or our patient to their doctors directly. It doesn't involve someone making decisions for that person. Why did we change? Why did we confuse people by having living wills and now call them advanced medical directives? It actually is trying to be clear. Many people have plans where they have last wills and testament. They have revocable living trusts, and then they have living wills. And even lawyers can get confused about what those documents are. So the trend now is to talk about that healthcare document in not very flowery, but pretty accurate terms. The person has the right to, in advance, make directions to their healthcare providers about how they want things to be done. And a common solution there is when the doctors have concluded that my end of life is here, please keep me comfortable and let me pass. I don't want any decisions to have to be put on the shoulders of family members. It's my decision that I'd like to pass comfortably and peacefully. What I want to do is take in each of these things that we're going to talk about today something I'm going to call a point of emphasis, maybe two, to talk about what's important for the individual to consider in these documents, because they are not one size fits all. The purpose of them is to allow you to specifically talk about your values and how you want things to be handled. They should not be pre-printed forms off of the internet. The first point that I want to talk about here is an example of an issue that became a point of conversation with my own father. I lost my father 2 years ago after an 11-year battle with Alzheimer's. And he had spent the 14 years before that being at least initially, primary caregiver for my mother, who was suffering with 14 years of Parkinson's disease. He had been a family man and you know, had a wonderful, meaningful, and an impactful life. But by the time my mother passed away, about 5 years ago, my father knew that his Alzheimer's was increasing, and he had a different perspective about how he would want care if he got to a situation where he was near death. The language that I put up on the screen here is the typical language we use to start a conversation as to when an advanced medical directive would kick in. Now, remember my hypothetical, once the doctors have decided that there can be no recovery from my illness, please keep me comfortable and then let me pass. All right. So what are the conditions when that applies? And of course, this is where the lawyer comes in to help talk about that. The typical person will say, well, I don't want this if I fall and scrape my knee. I want this when I've got a terminal condition. In fact, I want to be near the end of my life. And so many documents, this is language taken straight out of the Code of Virginia that you're free to modify. It's on the screen, and I'm going to read it. A terminal condition means a condition caused by an injury, disease, or illness from which, to a reasonable degree of medical probability, a patient cannot recover, this is the important part, and the patient's death is imminent due to the condition or the patient's in a persistent vegetative state. So what I want to focus on here are those two prongs at the end, the two Romanettes, 1 and 2. Number 2 talks about a persistent vegetative state. This is the Cherry-Shivo case. A person is brain dead, their brain is shrinking, there's no chance of recovery. This is not a coma. People wake up from comas. Persistent vegetative state is brain death. So that's one condition. I think most people would say if I've got a terminal condition and I'm brain dead, yes, that's when I want my end-of-life instructions to come into place. The other prong is, what if we don't have a person who's in a persistent vegetative state? That's where prong 1 comes in. The patient's death is imminent due to the condition, okay? So a clear example of that would be, I have a massive heart disease, and that's my terminal condition. The doctors all agree that sooner or later, the heart disease is going to kill me. But now I'm having a heart attack. My death is imminent. If they don't resuscitate me, I will die. Maybe not in 30 seconds or 3 minutes, but in a very imminent time period, I'm going to pass away. As you can imagine, however, that when we get to end-of-life situations, that's a pretty narrow condition. And I want to tell you about my father's view on this when he still had sufficient capacity to talk about it. When he had done everything he felt he needed to do in his life, when he had buried my mother and he saw the dementia coming, he worried about a phrase he used, merely existing. And he said in our conversation, well, I've got Alzheimer's. That's a terminal condition, all right? But if I'm choking on a chicken bone, or if I have a heart attack, I do not want someone to remove the chicken bone or give me CPR. Even though I might recover, I am at the end of my life, and I don't want to interfere with, he was a pretty religious man. If God opens a door for me to leave, I'm ready to go. I'm not going to slam the door. Now, this isn't advice that you should link these things together, particularly for people who are not near end of life because of terminal conditions. I think this standard language is usually more appropriate, but this is an important thing for you to talk with your lawyer about. Given your family situation and your personal circumstances, you might want to modify this language to suit your own needs. My father asked me to change this language to say that if he had a terminal condition and his death was imminent for any reason, we were to keep him comfortable and let him pass. Okay, there's that key language there. Another thing that I want to point out about the Advanced Medical Directive. I have a lot of folks ask questions about assisted suicide, which is becoming a more common topic of conversation around the country. There are several states, including DC, that have laws that will permit people to assist bringing about the end of life. We're not before the heart attack or before the choking incident. Can they get medication to actually accelerate the end? Virginia has not progressed that far. The most liberal laws on this are in the state of Oregon. I do think it's going to become more common around the country, particularly as dementias increase and impact more and more people's lives and produce lower quality of lives. But I do want to tell you about what can be done within the state of Virginia. And that is to say, you are allowed, when you direct your doctors, to not only direct your care, and that is to say the treatment of your illnesses, but you're also allowed to direct them in the treatment of your symptoms. And every once in a while, we find a person who is in an extraordinary amount of pain, but is still conscious. A great example of that may be brain cancer, pancreatic cancer, something like that, where because of medical ethics, the doctor cannot treat the symptom, the pain, by giving sufficient pain medication, because there's a risk that that pain medication could actually accelerate the dying process. The law in Virginia and in all other states does allow you to authorize your doctor in advance to treat your symptoms over the disease. That is to say, use language like this, authorizing the doctor to administer dosages of pain-relieving medication that may be in excess of a recommended dose, even if that medication carries with it the risk of inadvertently hastening death. They can't give it to you to kill you, but they can give it to you to ease your pain. And if that causes your cardiopulmonary system to relax or become subdued, and it allows the end to come, then ethically they're allowed to do it. And you, of course, are authorized to permit that. So some clients will not go that far. Many other clients do want to go that far. Again, the point here is that these documents are legal documents, and it's important that you talk with your lawyer to make sure that you are expressing exactly the right kind of decisions for yourself. Okay, the next healthcare decision document I'd like to talk about is, again, not a very sexy name, what we call a durable healthcare power of attorney. Durable means it survives your incapacity. So if you're unconscious, it's still in effect. And it's a power of attorney or an agency document naming someone to act for you to make healthcare decisions. This is generally the part we look to when we're not talking about end of life. Person has come into the hospital after a car accident. They're unconscious. The doctor believes the operation should occur on a kidney. But you know what? Doctors are not allowed to operate on you. It's called assault and battery if they don't have your consent, what's called informed consent. They need to explain to you the problem, the treatment, the consequences, make sure you understand that, you make the decision, and then they act. Well, if you're not able to do it, the law allows you to name someone who may not handle any financial affairs, but can be the one to make these decisions for you on these medical decisions. It could be about courses of treatment. It could be emergent things like operations. It could be hiring and firing doctors, moving from one facility to another. And particularly as we have people with longer declines in their healthcare, this healthcare power of attorney can be very important in making arrangements for where a person lives. Maybe they need to move to a nursing home or to an assisted living facility, hire and fire caregivers, this kind of a thing. So the durable healthcare power of attorney is widely recognized, happily relied on by caregivers because they really want to do what their patient wants. And any written direction you've given them about parameters like end-of-life instructions and direction as to who to talk to when another decision needs to be made, they're frankly thrilled to know that they've got someone that they can deal with if they can't talk to the patient. The point of emphasis I wanted to talk about in this document is a provision that you're likely to see offered to you by an elder law lawyer, but very unlikely to see in a traditional document from a traditional estate planning lawyer. It's what we call in our office the Ulysses Clause. Others will call it the Protest Clause. But let's talk just 3 seconds. Powers of attorney, even healthcare powers of attorney, are delegations or sharing of authority from our patient or our client to someone else. And when you share your authority with someone else, you always possess, as long as you're competent, the power to revoke that, right? So if I named a friend to handle financial affairs for me, I then found out that because of an addiction to drugs, he was abusing that power of attorney and stealing from me. I have a simple solution. I just revoke the power of attorney. Well, in the healthcare world, we have some special circumstances that can be a problem. Let me give you a situation. Husband has dementia or bipolar disorder. He has medications that typically help him function well and independently, but for some reason, he's gotten off of his medications. And he's very agitated, and in fact, maybe violent, and is acting out. And now caregiver, wife, is not only concerned about her husband's safety, she's actually worried about her own. So let's go through a thought experiment here. Wife gets husband into the car, goes down to the hospital because husband says, I'm not taking his meds. I don't need them. I'm fine. I don't want to take them anyway. So we go to the hospital. Wife tries to check the husband in using her healthcare power of attorney, saying, well, he said I can make decisions when he's not capable of doing it. We need to get him in and we need to get him back on his meds. Okay. Well, here's what can happen. Husband looks at wife, looks at the nurse and says, no, I'm fine. I'm not going. I refuse. And if the hospital says, well, we have this agency document here. You've allowed your wife to make these decisions for you. He says, well, I object to that. I revoke it. And the law says we have to respect that decision. And how do we take care of the husband in that situation? That usually devolves into something called an incapacity hearing, where lawyers are appointed, someone acts like a judge, there's a hearing. It is one of the most gut-wrenching things I've ever been involved in 32 years of practicing law, because our poor person who needs help feels like he's being betrayed by those people who are most important to him. And it can take from hours to days to get this process completed, where a judgment will be made that husband needs to go into the hospital and get back onto his medications. The purpose of the Ulysses Clause is, in states that allow it, and Virginia is one of those, when you make the arrangements early on and husband is clearly in control of his affairs and has capacity, husband can make a declaration in his document that under very certain limited circumstances, he trusts his wife so much that even if he protests, the hospital is to take her direction over his. Now, it's not every decision. It isn't a commitment for life. It's a maximum of a few days. And the way we know it's valid is that husband has to have his regular doctor or a clinical psychologist sign off at the time and say, oh yeah, Joe understood that he might be involuntarily admitted to the hospital for a few days. And he trusts his wife to make that decision, and he understands the impact of it. So we include a provision like this in the healthcare power of attorney. The client has the regular doctor co-sign it. And then if 5 or 10 years down the line, we find ourselves in one of these situations where husband is not cooperating and frankly isn't acting in his own best interest, we really can have our trusted family member go in and make that decision. I want to emphasize again, this is not committing someone to a nursing home for life. This is not committing someone to the loony bin for life. It's a matter of an admission to the psychiatric ward at the hospital to get sufficient treatment for an immediate problem. Okay, let's talk about other decisions outside of healthcare. Paying for bills, paying the mortgage, those kinds of things. For this, the traditional tool has been something called a general durable power of attorney. Again, durable means that it survives your incapacity. It's still in effect. You are naming someone to act for you. And the word general means it's just intended to apply to a broad number of circumstances. When I started practicing in the 1980s, the typical estate plan for my Virginia clients would be a will to deal with death and a durable power of attorney to deal with problems during lifetime. However, the world has changed. The financial world is very uncomfortable dealing with agency relationships on financial matters for two things. Main reason is identity theft has become the #1 crime, growing crime in the country. And the Great Recession caused a lot of financial liability for financial houses who had been taking investment direction from individuals acting under what were really rather narrow financial powers of attorney. And so it turns out that while a financial power of attorney is absolutely something that needs to be in your stack of documents, we do need to be aware that they can be very problematic. And there's a couple of reasons, and let me tell you why. The first one is the financial institution knows the law of powers of attorney is that they terminate as soon as someone dies. And when Joe's son or Susie shows up at the bank and wants to move dad's life savings, saying dad needs help, the bank's duty is to dad. And how do they know dad hasn't died? Because if this person who says she's Susie turns out to be a fraud, they could be harming their own client. And this is risky for the bank because they've got to make a decision about acting when they don't have any direct information about their client who might have died. Similarly, how do they know that dad didn't revoke the power of attorney? If Susie is there to do harm, she's not likely to admit that dad had revoked the power of attorney. Another issue is the appropriate identification of the person who shows up in this modern world where you can get a ID from the internet from somewhere in Asia. Banks are very concerned that someone shows up with an ID. Is this in fact the individual who is named in the document? And finally, the one that's become the broadest problem is what is the scope of the power being granted by this document? Online forms and typical estate planning lawyers' forms are actually quite narrow to protect their clients. Opening and closing bank accounts, doing very limited planning, in order to prevent a dire emergency, but also to protect the clients a little bit. This particular point is the one that caused the big problem in the Great Recession. A power of attorney may be created in 1985, said my son Joe can open and close bank accounts for me and buy and sell stocks. No one thought of the power of attorney again until 2008, when we had a lot of people investing in mortgage-backed securities, and we had a whole bunch of crazy losses. The average portfolio loss in the United States was 25%, and our seniors were way above that. The reason here was that the financial institutions hadn't taken a look at the scope of the power granted by the powers of attorney. They had just assumed that the agent could do anything. Well, in today's day, that's not happening anymore. I'm sorry to tell you today that I am still fighting with Wells Fargo. We delivered to them a valid power of attorney that I drafted myself, I witnessed myself, I was the notary public myself, delivered it to them on February 20th to manage an account with $5 million of affairs. The bank has still refused to accept the power of attorney, and we're going to have to go to a trial to compel them to accept the power of attorney. Now, the bad news in that case is, at last check, they've lost over $1 million because the market has crashed in this time period. I will get an award of fees from the court to compel the bank to accept my power of attorney. But the point is, these are documents we want to have for emergencies, but we don't really want to rely on them from a day-to-day basis because in a pinch, there could be a problem. Not always, in fact, maybe not even much of the time, but sometimes, for example, this family, really an unfortunate outcome. The way we help with decisions more and more these days, particularly with a parent or a client who may have a 5, a 10, or a 20-year decline and a need for assistance that may start at just a little bit and then increase, is using something called a revocable living trust. And this is, legally speaking, a different kind of a document to the financial institution or to the bank. Frankly, they look at it like a company. And all the business inside the company is up to the family. And if the document says Rory's in charge until he resigns or becomes incapacitated, then his oldest son becomes in charge, that's where the bank stops. Who has the authority to sign the checks? And I retain control. I can revoke it. I can change it anytime, but I don't have to worry about these concerns that I was talking about here before. The issue of termination isn't a question that the bank gets into. Revocation isn't a question that causes them to link up. I do still need to prove who the successor trustee is, but the scope of the power, that's all to the family to determine on their own. Here are the points that I want to emphasize about the value of a revocable living trust. It's very, very helpful because our trustee, who is our client, is the boss. You're not passing away, handing away, or giving away any authority. You actually remain the boss. Now, you can name a successor trustee to step in if you've died, if you resign and you just want help, or because you've incapacitated. But whoever that person is that you name is the boss for all purposes. And it makes it very easy for outsiders to deal with the family trust for the benefit of the individual. I call it in my office commonly a trust of convenience, because it is very convenient for loved ones to be able to use this to handle affairs compared to an old-fashioned power of attorney. You should also know that a revocable living trust works like a will. When a person passes away, the provisions of the trust move to a different chapter that say, once I've passed away, or once my wife has passed away and I've passed away, here's how I want the property in the trust to be distributed. And a nice effect of that is that if we have the assets in the trust, when the death occurs, we don't have to go through the probate process. Probate was created to make sure that people weren't, widows and orphans weren't taken advantage of by the 2 or 3 people in the county who could read. And it allowed for a required supervision to make sure that when a person died, their property was distributed in the appropriate manner. That's still the default way of dealing with things, but most people are able to understand their rights, and they don't want to spend $5,000 to $15,000 in taxes and filing fees to have a supervision of the distribution of their estates handled. So a revocable living trust doesn't solve every legal problem in the world, but with regard to managing affairs during a phase of incapacity, or handling affairs after a person has passed away, they are extraordinarily helpful. Frankly, I see no downside to them in terms of limitations of rights or control, but lots and lots of upsides. Let's talk now about tools to protect our clients. We're going to talk here about guardianships and conservatorships. You may have heard of the word guardianships. Not quite so many people have heard of the word conservatorships. I want to tell you the distinction between the two. A guardian is a person appointed by a court, by a judge, to handle personal affairs for a person. If I don't have an advanced medical directive or a healthcare power of attorney, the guardian is the one who would tell the doctor whether it's okay to operate on the kidney or to deal with end-of-life instructions. We have to go through a filing process. There is a litigation process. It can take several months. The court will appoint someone who makes those decisions for you. The second role is the conservatorship. The process is exactly the same, except a conservator handles money, not personal decisions. So many people who have not done any private planning end up needing both. Someone to make the medical decisions, where's the person going to live, and then who's going to pay the bills, who's going to manage those affairs. The point that I need to make about these as to why they are not favored by lawyers in general, and specifically by me, is because, one, they involve having to go to court. The first thing that the judge does is appoint another lawyer to participate in the process to make sure that there's no shenanigans going on. It can be very expensive and it can be very time consuming. But here's the main point. My job is to help people be independent and protect their rights. For a judge to appoint a conservator or a guardian, she must determine that the individual no longer has capacity to do certain legal acts. This is to say, there's not a sharing of authority anymore. The judge is going to say, Rory, you can no longer do this. You can no longer participate in medical decisions, even if you're awake, even if you're conscious. I am taking that right away from you, and I'm giving it to your guardian. Rory, you can no longer control your checking account. You lack that capacity. You can't sign any contracts. I'm taking that power away from you, and I'm granting it to your conservator. So you can see this is fundamentally very different. We prefer to do the voluntary planning, having the advanced medical directives, the durable healthcare powers of attorney, the financial powers of attorney, and the trust in place, because it allows us to make decisions within the family and avoid having rights being deprived, taken away by a judge, and we avoid the cost of going to court. One of the reasons that it is expensive is that when we talk about capacity, the truth of the matter is it's really a sliding scale. Decades ago, we used to look at capacity as an issue kind of like a light switch. You either were competent or you were not. The modern law is not that way at all in America. Capacity is actually a sliding scale. So the capacity to understand who I am, what I own, and how I'd like it to be divided up when I die is actually pretty basic. And people may suffer from all kinds of other problems in life, but still understand how they want to benefit their families when they die. Legally, that is the lowest standard of capacity. We call that testamentary capacity. There also might be the capacity to understand the the fraud that's being perpetrated on the telephone by the scoundrel who's trying to convince me that he's with the IRS, or that I've got a grandchild who's been arrested in the Caribbean and I need to send money immediately, or the capacity to buy a car when I really shouldn't be driving, all the way up to the capacity to put a man on Mars, okay? I think I'm a reasonably intelligent person, but I promise you, I do not have that capacity. So you can see that there is a real broad range here. And when we go to a position where we're going to enforce someone's ability to make a decision for you over your voluntary sharing of that authority, it's incumbent upon the court to understand very, very clearly what rights are being taken away. That is to say, what capacity is lacking. And only where the court determines that a capacity does not exist can the judge appoint someone to make those decisions. So it's not unusual for us to have an order from a court saying the person cannot enter into contracts, can't buy a new car, can't sell his house, but he can make medical decisions, can vote, can make decisions with regard to their living arrangements. But each case, of course, is very particular to the individual involved. And this is why there has to be a court process. So best of all would be to have our person do that planning voluntarily so that we never have to go to the court and have those arguments. Just find someone that we trust who can help with a broad range of decisions. Okay, we've got just a few minutes left, and I want to wrap up by talking about the third and maybe the most important thing. Realistically, we have to have money to use to pay the bills or to pay the caregivers. How is it that we do that? And lawyers, elder law lawyers, will use a couple of different trusts. I just want to highlight quickly that will allow people to protect their assets. We call them asset protection trusts. They protect family assets in a way under the law that allows individuals to use other funds, other sources to pay for that care. The first one we call a Veterans Asset Protection Trust. This is one that is used to provide benefits for someone who's 65 years old and needs help to be safe at home, who is either a vet during wartime or the surviving spouse of a vet during wartime. The second and more common tool we use is something called a Medicaid Asset Protection Trust. Again, this shelters the family assets from all kinds of creditors, including nursing homes and caregivers, and opens the door to other sources of payment for caregivers. The VAPT, or the Veterans Asset Protection Trust, is a defined benefit. It's a cash tax-free benefit for a married couple. I think it's $2,266 a month tax-free. That can be used to pay the unreimbursed medical expenses or any personal expense of the vet. An important point to emphasize here too is that surviving spouses of vets who served during wartime, that is to say, if you're a surviving spouse of an individual who served during wartime, you yourself may be entitled to a monthly benefit to help deal with care during retirement years. The other point to talk about with regard to the Medicaid Asset Protection Trust is that these are unlimited benefits, both in terms of dollars and duration of benefits. You could start receiving them because of a broken neck in a car accident when you're 20, and you could receive them for 80 years. If you're in Manhattan and the nursing home is $25,000 a month, they'll pay the bill for you to be there. Two quick points of emphasis before we wrap up and go to questions. I hear people ask the question when they hear the phrase Medicaid Asset Protection Trust, does that mean this is a welfare program and I've got to become impoverished? There is a program called Medicaid that provides health insurance for people in poverty. This program is something called ABD Medicaid. It is not about impoverishment. It's actually about, it's designed to protect families from impoverishment. You've actually paid for this long-term care insurance just like you've paid for your Social Security. and your Medicare health insurance. Okay, let me take a look at my handy dandy iPhone. 12:44. I was supposed to finish at 12:45. Juliana will be stunned that I'm actually ahead of schedule by 1 minute. But oh yeah, last point is 75% of the people who use that Medicaid benefit use it to pay for caregivers to stay at home in their own homes. Vast majority use this to stay at home. Okay, so that's the end of my formal presentation, and that took away my last minute. Juliana, I guess I hand the baton back over to you, and let's invite the group to give us questions.
Thank you, Rory. That was very insightful. Yes, we want to invite all participants to please submit your questions through the Q&A box. We do have a few questions. One of them is, if Virginia is a next of kin state, why is it important to have a medical advance directive? And I know that you've talked about it, but if you could explain a little bit more, because I have heard people say, well, you know, you don't really need it because it's a next of kin state. So you'll be the one making the decisions. Okay. And who should have a copy of that medical advance directives? Okay,
so let's take those in order. So the first question about next of kin, the first point is, when a patient comes in and has presented their own document, there is absolute focus on what the intent of the patient is. And that is the be-all and the end-all in medical ethics, just as it is in the legal world. The law has a backup plan in place for people who don't have it, but the direction about when to provide what kind of care and the authority of the individual and when they have that authority is not as clear under the statute. So for example, if I were to name my spouse as my agent, if I couldn't act on my own, and I have two sons. I have a 25-year-old with autism and a 23-year-old who's trying to get college finished. I would be very happy to have my 23-year-old son make a medical decision for me. I would not want my older son to be put in a position of making that decision for me. Even though he's competent, he would find it overwhelming personally. He would find it very anxiety-provoking, and it probably wouldn't be good for him or for me. Another issue is who is in charge and when. So for example, under a written document, I could say my spouse is first, but if she's not available, my named son can make decisions for me. Well, if my wife has a job where she works in a secure location and can't be reached, my son can automatically, under my document, make decisions until they reach my wife. She can then pick up the baton and make those decisions for me. So the statute isn't very clear as to when we deal with a class of people. Sure, we can only have one spouse, that's true, but we can have many children, we can have many siblings. And who has authority? The problem is that when we're in a life or death situation in particular, or when an operation needs to be done, the family dynamics of having a spouse, 3 kids, kids from a prior marriage, all together in the same room trying to make a decision doesn't do anything except create anxiety, hesitation, and a problem for the healthcare givers. We're trying to help the healthcare givers. So it's not that you don't have anything, it's that you really don't have the best possible tool. Next question was, who should you give these to? And there's some good news here too. Back in the day, back in the 80s, we used to typically give our clients 7 or 8 copies of their healthcare directives and powers of attorney and tell them to hand them out like candy so that if there was a situation, somebody would be able to find one quickly. In the modern world, there is a registry. If we notarize the document, we can upload it into a database. And if you're in Hawaii on vacation, they can check that database and find your document there, or any place in Virginia. We also give electronic copies to our clients so that they can carry them with them as well. We maintain our own online accessible database. So here's the thing that you do need to know. I had a small medical procedure done for myself last week at the hospital here in Loudoun County. I needed to go in for a test. When I went in, they asked me if I had a document. I gave them my document. They sent me home, and then I came back 2 days later and was admitted to the hospital. You know, they open a new file on you every single time you come. And even though I had given the same hospital my document 2 days before, I brought a second one when I came to the hospital on Wednesday to make sure that it was going to be in my electronic record right there. You would think that the original signatures are a very important thing. In my practical experience, is an electronic copy of the document, as long as no one's challenging that it's authentic, is perfectly good. So we'll give an original now. Suggest that people take a copy every time they go in for a test, every time they're admitted to the hospital. Forget it. Give it to them. Leave it. Just print out a new one the next time you go. If you live in a small rural community, you might want to give it to your family doctor, because that doctor probably has a file for you and it would be in your file. But in the urban areas, everything is electronic now, and you should give it to them each and every time.
Thank you. We do have a few more questions. The next question is, did I hear you correctly that MAPT is taken out of your check while you're working? If we need it, how do we apply for it?
Okay, so that question there has to do with receiving ABD, that stands for Aged, Blind, and Disabled Medicaid Benefits. Since 1965, your employer has deducted from your paycheck a contribution for Social Security, a contribution for Medicare, and an equal amount for this long-term care insurance called ABD. The way you apply, and everybody's used to Social Security, you know that's not a welfare program, you paid for it. Everybody understands Medicare, that's health insurance for seniors. Far fewer are aware that they actually have a long-term care insurance benefit. And this is because we don't make an application for it until the need is there. And the way we demonstrate to the government that they should pay the bill for our client is we prove to the government that our person has done what the government wants, protected the family assets to make sure the family will not become impoverished because of a situation. That's why we create the trust. We create the trust to shelter the assets. You can use the money to go on vacation, take cruises, buy Christmas presents, do whatever you want. You're in total control of the trust, but they're sheltered from creditors. And then the government says, you've got a legally sufficient trust. Now that you have a care need, you need someone to come home and help you with laundry, do your cooking, take a bath, those kinds of things. The ABD program or the state of Virginia will pay that bill. So there's two ways. So if you're retired, you're already done paying your premiums. That's the good news. You don't need to buy a long-term care insurance policy, sign up and apply. That you're done. If you're still working, you're actually still making a contribution. And as a matter of fact, your boss is matching those contributions. What you need to do is arrange your assets to show the government that you've met the public policy, you've protected your spouse and your kids from impoverishment. Then when the time comes for care, an application is filed. It's submitted with your local county. Someone like Juliana would receive that, review it, make sure that you meet the application criteria, and then connect with the caregiver and make payment directly to the caregiver. This is pretty sophisticated stuff. As you can imagine, it's not unusual for a nursing home bill in our area to be $16,000 a month. And month after month after month, that adds up pretty fast. So it does need to be done correctly. And this is not the kind of thing that an estate planning lawyer can do for you, but an elder law lawyer, that's really the essence of what elder law lawyers do. One, arranging your affairs so that you qualify for the benefit, and second, making the application so that the dollars can be paid. I think that answered the question, Juliana.
I think so, yeah. And you said ABD is for, it stands for age, blind, and disabled. Is that correct?
Yeah, aged, over 65. Blind means legally blind in at least one eye, 2400 vision in your best eye. So you could be 40 and blind, or disabled. And as I mentioned in my example before, you could be 20, have a broken neck because of a car accident. If you meet the definition of Social Security disabled, incapable of gainful employment, and that's likely to persist for a year, even though you're under 65, you're still entitled to the long-term care benefit. If you meet the other requirements.
I think we still have a few minutes for a couple of questions. Maybe we'll try. Is a lawyer needed or recommended to apply for Virginia state Medicaid benefits?
It depends. Because the rules are drafted to encourage people to shelter their assets, they want to have one rule that applies to everyone. So the misconception that people need to be impoverished comes from the fact that one of the rules is that the person who's applying has to have less than $2,000 of something called countable resources on the day they apply. That's $2,000 is not very much money. So a person may on their own say, holy cow, mom is in, dire financial straits. But if she has a balance in her checking account of $3,500, they're going to be denied. So there isn't a legal requirement that you have a lawyer to file the application, but you should have a lawyer help you to make sure that you qualify so that you don't have a waste of time. You could spend 45 days to 90 days waiting for the government. They could reject your application, and then you have to privately pay for those bills when something simple might have been able to be done before the application is filed. So want to be clear, it's like any other legal solution. The lawyer's value is in anticipating problems and making them go away in advance. But the direct answer to your question is no. If a person is eligible and does not need any planning to be done, the application's online. Once you're prepared, once you're ready to go, it's a pretty straightforward process. The rubber usually hits the road because people do have significant assets that need to be arranged or sheltered in advance of the application. But that's very insightful. Two things, planning and applying. The applying can be much more straightforward. You don't have to have a lawyer to do it. You do have to have someone who has legal authority to make the application, however. So an agent under a power of attorney, for example.
Thank you. We have another question. When should I start getting these documents together for me and for my loved one? And do these documents transfer to another state if I move?
Great question. Okay, so this is also kind of a sliding scale. When I talk to families who are in their 30s, their principal focus is who would be guardian of their children if they should have a terrible car accident. So if you have kids and you don't have any documents in place, you're at risk. In this crazy COVID-19 world, if you work in a situation where you're a healthcare provider or an emergency responder or a person who's got common contact with people who might be sick, you believe it or not, we've been very busy in the last month with people who are very young, have no health issues, but worried, what if I were to get COVID-19, who would make decisions for me? So generally, it's where are you in your life and what are your risks? If you're single and you don't have a spouse who depends on you and kids, you can probably put the decision off with very little risk. But if you've got minor children and a spouse and you've got significant assets, then yeah, you probably ought to have at least some fundamental tools in place. I start seeing people talk about the long-term care benefits, the asset protection, usually at a later phase in life. When they're 55, 60 years old, they're thinking about retirement. That's an ideal time to make these arrangements because we also make sure all the basic things are covered. If you've got a loved one, however, who is facing a decline or potentially can face a decline, the time to act is now, because we want to do as much sharing of authority and avoid the necessity of going to a court if we can. And I can tell you, unfortunately, over 30 years, more than a handful of times, clients have said, well, I know I need to do this for mom, but this is going on and kids need to go to college and so, we'll do it next month. And then that's the weekend that dad falls and hits his head, or that's the weekend mom has a stroke. And all the dynamics change when we're in an urgent situation. And of course, the impact on the client is not only is it much more stressful, but it's typically more expensive. And sometimes we have to go to court. So for your parents, if you see yourself being the hero, the one who's going to make decisions and help balance the idea of that you're not interfering with their lives, you're asking them to help you. You know they're going to want to trust you when they need help. Why don't you work together now to put some arrangements in place? Certainly, as soon as you know there's a health issue, you should get those done for yourself. By the time you're around reaching the age of retirement, you should be thinking about the long-term issues and the fundamental things like powers of attorney and having a trust and healthcare decisions should be done as soon as you've got something to lose. If you got a spouse, a kid, or assets at risk, that's it's not too early to go talk to a lawyer. Hope that was helpful and not more confusing, Julia.
It was very helpful, and thank you. We are about on time actually to end the webinar, but there were a couple of things that I wanted you to address. Do you offer free consultations at all?
Absolutely. I have a client services director. Well, we've got 12 people in our firm. This isn't just me. We're actually pretty large for an law firm. We handle things from elder exploitation, guardianships, advanced planning to Medicaid applications in a crisis situation. If folks have questions about this kinds of things, would like to get more information, I encourage them to give us a phone call at the number on this slide. Ask for Liz Grannis, Grannis, or they can ask for me. We are working from home to try to keep our clients safe, but we can be in touch with people very, very quickly. In this COVID world, we are doing meetings precisely with this same system, Zoom, where I can meet with a client, see them face to face, hear them, and I can put up on the screen, as I've done here with my presentation, their draft documents, and we can talk about them so they don't have to be worried about coming into an office and picking up any bugs from anyone. So please, happy to talk to anyone.
Thank you, Rory. And we are getting ready to wrap up. So as you signed out, there will be a brief survey. Please take a moment to answer those questions and help us provide topics that you are interested in. We do have 6 more webinars scheduled for this year. Our next webinar will be on medications and aging, and it'll be on Wednesday, June 10th from noon to 1 p.m. Rory, really, thank you so much for being here with us today. Like I said before, your presentation has been very, very insightful, and I know there were a few questions that we were not able to get to it. But I don't know if I can email those to you later.
Please ask people to either, my email is rclark, R-C-L-A-R-K, at the Legacy Elder Law Center, or give us a phone call if they want to forward them to you and you want to forward them to me. All of that is fine. I'm in the information business and I'd love to share information. And I want to thank you for asking me to participate in this. Juliana and I don't know if it's been 10 years, but we've worked together for a long time. She is a wonderful service to the community and a wonderful person. And I appreciate her including me in her plans to help educate the folks in Fairfax.
Thank you, Rory, and have a wonderful day. Thank you, everyone.
Thank you all. Bye-bye.
Bye.